State versus Ashley Clark, 22 CR 216. Mr. Fosgrove.
No. Your Honor, this comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm going to make a motion for my attorney to withdraw. I got this myself.
Oh, okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right.
All right, guys, today we step into a courtroom moment where confidence and chaos collide from the very first minute. We see Ashley Clark facing a probation violation hearing, but the twist hits fast when she decides to fire her attorney mid-process, believing she can handle everything herself. The judge explains rights carefully, but she insists on self-representation. What looks like confidence quickly feels like a risky gamble as she walks away from a prepared legal deal into uncharted territory. A decision that sets the tone for everything that follows, and the courtroom is about to see why that choice matters.
Well, I've already gone over these rights with you, so you should understand them, but you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one. You qualified. You do have the right to represent yourself as well. And that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence just as if you're an attorney. You understand that?
Yes, sir.
All right. Has anyone promised you anything or threatened with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want to contest the hearing?
I'm going to contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab him real quick.
Okay. Okay, state has the burden. Any opening statement, Mr. Marcinski?
No, sir. Thank you.
All right, Ms. Clark, any opening statement?
No.
All right. State may call this first witness.
Thank you, sir. The state would call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
The judge ensures she understands her rights, warns her she must follow procedure like an attorney, yet she still chooses to proceed alone. The waiver is accepted and suddenly the tone shifts from caution to exposure. With no lawyer, she rejects the earlier stipulation and demands a contested hearing. The state calls its probation officer as the key witness and the courtroom energy tightens immediately. This is where the case starts building real weight against her, setting up testimony that will define the outcome of the hearing.
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes,
And what was the result of that UA sample from Miss Clark?
it was positive for methamphetamine.
So her UA was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines?
That's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No.
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
Yes, and I did. I received that, and apparently she has new charges.
To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
No.
The probation officer takes the stand and the evidence begins stacking fast. Drug testing confirms methamphetamine use and the defendant even admitted it in writing. Missed reporting dates and failure to appear are laid out clearly, leaving little room for doubt. The officer confirms she has not complied with supervision requirements or stayed in contact. Each answer tightens the noose as the prosecution builds a straightforward violation case step by step. The foundation for revocation is now firmly in place and the courtroom knows where this is heading.
All right. Do you have any further evidence or witnesses, Mr. Marcinski?
Not at this time, Your Honor. I do not.
All right. Ms. Clark, you have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
Right now I see no evidence. This has the needed personal subject matter jurisdiction.
If you want to present any evidence, do you want to present any evidence?
No.
No? Okay. Well then, closing argument, Mr. Marcinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying sentence.
All right, Ms. Clark, closing argument.
The defense phase offers no real counter as the defendant chooses not to present evidence or witnesses. Instead, a sovereign-style argument appears questioning jurisdiction and the legitimacy of the state itself. The prosecution calmly shuts it down and sticks to the facts already proven through testimony. Closing statements from the state emphasize repeated violations, drug use, missed reporting, and failure to comply with treatment conditions. The argument for revocation becomes overwhelming, leaving the judge with a clear decision ahead.
There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Okay. It'll be the order and judgment of this court. Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated, it does in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve her sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
In the final moments, the defendant attempts a jurisdictional argument claiming the state has no standing, but the judge moves straight into findings of fact. The violations are confirmed one by one, including drug use, failure to report, and non-compliance with treatment. Probation is deemed ineffective and revoked, leading to immediate remand into custody. The courtroom reality hits hard as legal theories collapse against documented evidence. The video closes with a reminder that self-representation without understanding the law often leads to the harshest outcomes. If you enjoyed this breakdown, make sure to like the video, subscribe to the channel, and we will see you in the next one.